Bits of housekeeping. Today's session will run for about 40 to 45 minutes, and there will be opportunities for questions at the end. So that might take us a little bit over the 45 minutes because there's quite a lot of material to cover this morning. If you do have questions, feel free to post those questions in either the questions area or the chat box in your GoToWebinar control panel. I'll be monitoring those as we go through today's session. There is a couple of polls that we'll be running during the session just to make sure you're awake, and also to find out, what the situation is in relation to this particular topic as it pertains to you as an advisor. After the session, there will be an email, or actually when we close the session, I think on your screen you'll get an opportunity to complete the feedback survey and reflections questionnaire. And if you don't do it at that time, you'll also get an email about an hour later, I think, that has a link to that survey and reflections questionnaire. Your feedback is really valuable to us because it helps us to tailor and adapt our programs to support your particular views and needs. It also is important from the point of view of structured CPD. So today's session is eligible for 1 hour structured CPD, subject to completion of the reflections questionnaire, as well as it being relevant to your own professional development program. I think for most members this will be totally relevant. Okay, it's now my pleasure to introduce Susan Taylor, who has once again taken time out to talk to us today about a very, very hot topic, particularly in light of the recent FMA report, and that is replacement business. The FMA report was released at the end of June and has had some critical analysis which suggests that in fact it was fairly limited in its scope, and I think that's right. However, it did highlight that there are some replacement business practices that need to be looked at, and it's not that it doesn't seem to be broad-ranging, but there are some pockets of advice where there are advisors who are actively or regularly replacing business for their clients and raising questions as to whether in fact it is in the client's interests. It's not, as I say, the report doesn't suggest it's broad-based, but it has highlighted to the FMA that there are certain particular individuals that they've identified who are regularly replacing business, and they will be investigating them further. Susan, good morning.
Good morning, David.
Thanks once again for taking the time out and sharing your insights into this, as I say, very, very hot topic. We look forward to what you've got to say this morning. If you have, at the end of the session, if you do have questions, feel free to email me or email Susan about this topic. But Susan, over to you.
Great, and I just want to check, David, you can all see my PowerPoint, can you?
I can't see your screen at the moment, no. You need to share your screen.
Okay, we'll just have to share that. So bear with me while I do that. Right, should be on there now, I hope.
All good, yes.
Lovely. Okay, well, thank you everybody for taking time out of your busy schedules today to attend this webinar. And as David has said, really the timing is very apt because of the release late last month of the FMA's report into churn. I'm having a few technical difficulties here because I'm trying to move my PowerPoint on.
If you just click your mouse, it should.
Yes,
Is that not?
Doing it before, but aha, done it. Right. Now, I'm assuming that many of you will have read or at least glanced through the FMA's report, and if you haven't done so, I suggest you should. But in essence, the FMA identified that replacement activity carries the highest risk of potential churn, where the switch is primarily done to benefit the advisor rather than the client.
Susan, can I just stop you 1 second?
Yes.
Can you have you moved the slides on?
I have.
We're still seeing the original, or at least I'm still seeing the original, the main slide.
Okay. Just a minute, I will just...
That's it. We can see that.
You've got it now?
Slide now.
Yep.
Yes, we are. Yep.
Got a picture now of the FMA report.
We have.
Great. Okay, and so the report reflects that the current remuneration structures used by the insurance providers present the risk of conflict of interest that could harm consumers and negatively affect the overall price and therefore accessibility of life insurance to New Zealanders, which, as we know, is very important because figures show that New Zealanders are vastly underinsured when it comes to life and income protection insurance. The FMA said that they saw that the majority of advisors don't have high levels of replacement business, regardless of the way they're paid for their services. However, as is usual really with all sectors of the financial industry, there are a small few that whose behaviour is perhaps less than ideal that unfortunately tend to give then the whole industry a bad name. And certainly, as David said, the FMA have identified some individuals where there was a clear link between very high rates of replacement business and high upfront commissions or incentives for high sales volumes such as overseas trips laid on by providers. So with that in mind, I'm going to talk to you today about the complaints that we've seen arising from the sale of replacement insurance, the lessons that can be learned from those complaints, and I'm going to finish by giving you some tips and our best practice guidelines as to how to avoid the risk of receiving such a complaint yourself in the future. Whenever we have complaints come to us, we're always looking at what lesson can be learned from this complaint, why did this happen, what went wrong, and then sharing that with our other participants to, so as I said, so to avoid the fact or the possibility that you could receive a similar complaint in the future. And I think it's fair to say that we've actually seen a rise in complaints over the last couple of years coming out of the sale of replacement insurance. And they're often very difficult complaints to resolve, sometimes because it's very much a he said, she said situation, but also because there are often very high emotions involved, and usually the complainant in particular is highly stressed, emotional, because they've had an insurance claim declined, and worst case scenario have found that they've got no insurance cover at all going forward. We expect to see this trend of increasing case numbers in this area continue over the next few years. Now, of course, a client's risk of changing policies is that a claim that would have been paid out under their old policy is declined under a new one. And the advisor's risk is that when this happens, the client turns around and blames the advisor. Therefore, without comprehensive advice to explain why the solution that the advisor recommended is in the client's best interests, the advisor is likely to struggle to answer the question that will be asked, certainly when we start our investigation, as to why did you recommend a change. We find that clients are often not aware of the risks involved in cancelling an existing insurance policy and moving to a new one, and they'll rely very heavily on an advisor's advice when it comes to comparing what they already have and a new policy. We find that most clients don't understand what non-disclosure means, nor do they realise that forgetting to mention something as simple as a doctor's visit in an application process could result in a claim being declined in the future. And additionally, clients don't understand commission implications when they change to a new insurer. And this potential conflict of interest, when fully disclosed, may cause them to apply more scrutiny to their own decision making. So the typical case that we see is where the client has failed to disclose a pre-existing medical condition for which they would have had cover had they stayed with their existing insurer. And unfortunately, that failure to disclose to the new insurer has resulted in a declined claim some months or even some years later. They then turn around to seek compensation from the advisor, and the compensation they're seeking can amount to many thousands of dollars, as I'll explain in some of the case studies. Now, David, I thought perhaps at this stage it would be useful to run the first poll about whether anyone listening in today has received complaints relating to the sale of replacement insurance.
Okay, so up on your screen will appear a question. If we can get as many people on the line answering it as possible, we will be able to share the results. So the question is, have you had a client complain or express dissatisfaction that their policy did not cover them for what they expected? We'll give it sort of 10 seconds for people to finish voting. It's 75% voting so far, 76. See if we can get close to 100. I don't think we've ever had 100 on our voting before, so maybe we can manage that today. Okay, 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Oh, I got pretty close to it. Got 92%. Okay, the answer to the let's bring up my webinar control panel. Let's share the results. So, Susan, 6% of respondents said that they had a complaint in relation to this particular question, and no were 94%.
Good. Well, that's excellent. It sounds like most of you listening in are following best practice guidelines already, which it's obviously very encouraging to hear those results. And as I said earlier, often we find that the great majority of advisors provide expert and very considered advice to their clients, but a small section can let the industry down. And of course, we do get complainants from time to time that are possibly trying to have it on. It's something that they know that they should have disclosed and they didn't, and when they've had the claim declined, they're looking for somebody to blame for that rather than obviously taking personal responsibility for it.
Yes, unfortunately, it's these complaints that get the most media publicity as well, isn't it? So they
well, it is, which
everybody else.
Yes, which of course is one of the benefits of belonging to a dispute resolution scheme, and really why we do encourage you, if you do get a complaint and it looks like you've got a difficult complainant and it's not going to be an easy one to resolve, to get it to the dispute resolution scheme as quickly as possible, because we look at complaints in confidence. If there is any form of settlement, a confidentiality clause can go into that so that you make sure that you keep it out of the public eye. Right, the first case I'm going to talk to you about today is I've called it replacement cover, replacement knee. And just to let you know that all of the names we use today have been anonymised, again to protect both the advisors and the complainants' confidentiality. So in this case, the complainants, who I've called Andy and Sarah, they had health and life insurance cover with insurance company A. And in September 2014, Andy met with an insurance advisor to discuss whether they could get the same level of cover with another company for a lower premium. They were keen to reduce the amount of money they were spending on their insurance. And the advisor went through Andy and Sarah's financial position and analysed their insurance needs and then prepared a plan for them. And part of the plan was for Andy and Sarah to change their life cover to insurance company B and their health cover to insurance company C. So there were going to be two new insurers involved. Now, around the time that this was happening, Andy went to see his doctor about what he thought was a minor problem with his knee, but he didn't tell the advisor about this. And in the meantime, unfortunately, while the proposal had gone off to the new insurers and Andy and Sarah were waiting to hear back, Andy went and cancelled his existing health insurance cover. Now, when the new insurer received the application, it sought a copy of Andy and Sarah's medical records, and the records included reference to the recent consultation Andy had had about his knee. And so the both insurance companies did provide Andy and Sarah with life and health cover respectively, but they both excluded cover for any claims in relation to Andy's knee. And as I've said, by this time, unfortunately, Andy and Sarah had already cancelled their existing health and life insurance with their original insurance company.
Quick question,
And you
Susan. Can I just...
Yes, sorry.
Carol's just asked, are you talking about medical cover or income protection type cover?
No, this was actually medical health insurance cover, so to pay for the cost of operation, because as Andy discovered shortly after this process, he discovered that in actual fact his knee problem was not as minor as he thought, and he was going to need knee replacement surgery costing around $20,000.
Right, thank you.
So, of course, on discovering he no longer had insurance cover, which, as I said, he would have had under his original health insurance cover, he met with another insurance advisor, and ultimately he and Sarah were able to reinstate their original health insurance cover with their old insurance company, but there was an exclusion in relation to the knee operation. So Andy complained to us that the advisor should have warned him and Sarah quite strongly not to cancel their existing policy before ensuring that the new policy would provide them with adequate and the same cover as they had before. He claimed that the advisor could reasonably have been aware of the issue with cover for his knee, and as a result of his actions, Andy and Sarah were now going to be out of pocket by close to $25,000. The cost of the operation had gone up because there was another specialist to see. So in this case, we decided when the complaint came to us that this was a case that would be much more suited for conciliation rather than trying to impose a decision. And we often suggest around the table conciliation in cases like this, particularly where they involve a bit of he said, she said, and perhaps have a few grey areas. Again, the conciliation process is entirely confidential. It gets the parties around the table. One of our case managers, all of whom accredited mediators, run the conciliation, and we have about a 95% success rate with conciliations. So in other words, the case is settled on the day, a settlement agreement is signed on the day, it's all confidential, and both parties can then move on. So in this case, once we'd spoken to both parties, it became clear that there were a number of grey aspects. It looked like the advisor hadn't acted as prudently as they should to have warned Andy and Sarah about the risks of cancelling existing insurance cover before they've had acceptance of their new cover with the new insurer. But there was also some doubt as to whether Andy had fully disclosed to the advisor exactly how bad the problem with his knee was. So the upshot was, at the end of the conciliation, basically there was no admission of liability by either side, but the agreement was that the advisor would pay compensation to Andy for roughly half the cost of his knee replacement insurance, and that was full and final settlement. Now, I might add that this case had been referred by the advisor to his PI insurance company, and when we're holding a conciliation conference and where there's a reasonable sum of money involved, the PI insurer will often want to have some involvement. Sometimes they'll want their solicitor present at the conciliation, and we're quite happy to facilitate that. The solicitor doesn't take any part as such in the conciliation, but they're there to say yes or no to any settlement that's reached during the conciliation conference. So that case, both sides, I can say, walked away reasonably satisfied with the outcome. Now, the second case I'm going to describe...
Can I just ask a quick question on that case study, Susan? You mentioned that you felt that the advisor hadn't acted as prudently as perhaps he should have done. Were there some specific elements that you would have expected to see which would suggest he was acting more prudently than he had? Or what were the factors that led you to that view?
Well, the complainants, Andy and Sarah, are absolutely adamant that they hadn't been told anything about the risk of cancelling existing insurance before knowing that they'd been accepted on the same terms with the new insurer. The advisor was a bit vague about it, and there was certainly nothing in writing to say that he had explained that risk to Andy and Sarah. So I guess the
Right.
lesson learned out of that, which I'll come to later too, is to make sure your advice is documented in writing, because had he
Understand.
been able
Yeah.
to show that, this case probably would never have got as far as a conciliation.
Cool. And just quickly, the PI. There's a quick question. I think you answered that, but I'm not sure. The PI insurance covered the advisor's portion of the claim, did it?
Yes, it did. Well, subject to any excess, of course.
Yeah. Yeah. Yeah.
But yes, and that's why often, as I've said, if it's a reasonable sum of money involved, and assuming the advisor has got PI cover, so I assume most, if not all of you, will have, the claim is obviously notified to the PI insurer, and they get involved just in the background. We don't want them running the show, so to speak. But I might add that we're finding that a lot of PI insurers are liking the dispute resolution process, because, again, we're much quicker than the matter having to go through a court. It's kept out of the public eye. We don't have lots of lawyers involved and additional legal costs, and the whole case can be settled reasonably quickly, which of course saves everybody a lot of time as well. And as we all know, time equals money as well.
Absolutely.
Right, the second case I'm going to describe to you is a case again involving non-disclosure of pre-existing medical conditions, and we had, I might say, a very difficult complainant in this situation, which unfortunately we seem to see more and more of these days. And in this particular case, the complainants, Keith and Nicole, it's another health insurance case actually. They had health insurance with an insurance company which they'd had since 1998. But early in 2014, they received a notice from their insurance company that it was no longer going to be providing health cover, but it had secured cover for its customers with another insurance company, we'll call it Company B, and they would be able to transfer their cover to Company B, and that new company would continue to cover any of their pre-existing medical conditions. So in other words, they weren't going to lose any benefits by transferring to the new company. About a month later, while they were still making up their minds, Keith and Nicole met with an insurance advisor, and the advisor said that he could offer them equal, if not better, cover with a third company who we'll call Company C. And he helped them fill out the application forms and take up the new insurance company's offer of health cover. So in other words, Keith and Nicole didn't move to insurance company B. They took the advisor's advice and moved to a completely new separate company, who I've called Company C. About 6 months later, Keith began suffering some quite bad pain in his thumb. He needed a steroid injection and met with a surgeon, and was told that he was going to need an operation on the thumb. I might add that Keith had been a builder for many years, so this was probably a work-related condition. Now, as part of the claims process, the insurance company C, of course, sought for Keith's full medical records, and these revealed that Keith had a number of undisclosed health issues. Not only had he failed to disclose that he'd been having some thumb pain for probably a couple of years on and off, but he had a number of other health conditions, including a back problem, a problem with one of his shoulders, and deafness. So the insurance company said, well, sorry, we're declining the claim for the thumb operation, and by the way, we're also going to exclude a number of your other health conditions from the policy. Keith and Nicole took instant offence at this and felt that this was yet another case of an insurance company trying to wriggle out from paying a claim. And in high dudgeon, they cancelled their health policy, and they also cancelled Nicole's policy, which unfortunately was a very unwise thing to do, because it transpired a few months later that it looked like Nicole was going to require major operation on her knee, which probably would have been covered had they not cancelled her health cover. Now, Keith and Nicole complained that the advisor was at fault. They said that he hadn't carried out a proper risk assessment when he recommended that they take out cover with Company C, that he should have taken more care in discussing their various medical conditions with them. And they also were strongly suspicious that the advisor had been acting in his interests rather than their interests when he suggested the new company, because he received commission from the new company. He wouldn't have received any commission had they simply transferred from Company A to B, as their old Company A had suggested. So they said they wanted the advisor to pay for the cost of the operation on Keith's thumb, which was going to be about $12,000. And they also put him on notice that Nicole might be needing a knee operation, which was going to cost around $25,000 to $30,000. And they also complained about the fact that they no longer had full health cover as they had previously had. So again, we interviewed the parties at some length, and we took a good look through the advisor's file. We found actually in this case that the advisor's process had really been pretty good. He'd met several times with Keith and Nicole and had highlighted to them that any advice he offered was only as good as the information he received from Keith and Nicole. And he said that he mentioned several times during a couple of meetings with them that it was very important for them to disclose their full medical histories, even if they thought that some of that history might not be relevant to the insurer. And he told Keith and Nicole that the number one reason that insurance companies don't pay claims is because of non-disclosure. He had done a written recommendation, and he'd discussed the benefits and advantages of the cover with the new insurance company while drawing comparison to the other insurer that had been recommended to them. And he said that he was recommending the new insurance company because it had higher levels of cover for certain operations and conditions, including in particular higher cover levels for certain types of drugs. Now, when he came back to pick up the proposal form that Keith and Nicole had filled out, Keith had disclosed that he had a problem with a right ankle, and Nicole had also disclosed a few unrelated to her knee health issues. The advisor said that if he had known Keith's full medical history, in other words, that he had problems with his back and obviously the problems with his thumb that was going to require surgery, he would never have recommended that they change to the new insurance company, because clearly it was likely that the new insurance company would exclude any claims related to those conditions. So on the whole, we found that the advisor's process had been very thorough. And we also found, certainly in relation to Nicole, that it had been her decision to cancel her health insurance policy, really, as I said, because they were in a height of indignance, I suppose, that the insurance company had declined Keith's claim, and had she not done that, she would probably have had cover remaining. So that knocked out her claim for the knee operation. We looked at whether the advisor could have been influenced in the fact that he would be earning commission by recommending the new company C, but we had no reason to doubt the advisor that he would certainly have not have been recommended moving to the new insurance company if Keith had disclosed his full medical history. Now, we also asked to have a look at Keith's correspondence with the insurance company when the claim for his thumb operation was declined. And those emails made it very clear to us that Keith had a pretty strong view that a lot of medical history wasn't relevant to an insurer's assessment of whether or not to cover him. However, the emails also showed that Keith thought that the new insurance company was going to look at his full medical records as a matter of course. And that was where we found a very small degree of fault by the advisor, because the advisor hadn't told Keith and Nicole that the new insurance company wouldn't, as a matter of course, review their medical records before offering them insurance. And I have to say again, that's a fairly common misconception we find with people. We find that a lot of people think that insurance companies will automatically get their medical records, when of course they won't, unless perhaps there's been something in the application form that's put the insurance company on notice. So it would have been best practice for the advisor to have told Keith and Nicole quite clearly that that an insurance company won't automatically seek medical records. And David, that might be an opportune moment for our second poll, actually. I'd be interested in whether our listeners automatically tell their clients that insurers won't, again, automatically seek medical records.
Okay, so we've got another poll coming up, and so we've got 92% last time. Let's see if we can get 100%. So the question is, do you tell clients that an insurer will not automatically ask for their medical records? So the question is the options you've got are always, sometimes, occasionally, or no. So we've got 65, 70, count down from 10, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, close. Okay, let's share the results. Okay, so this is a much more varied response to this question, Susan. 41% always, 24% sometimes, 16% occasionally, and 18% no. So it's quite a diverse range of positions.
Yeah, that's interesting. Well, you know, my tip to you here is always do it. As I've said, we find with talking to a number of complainants that it seems to be fairly common across the board that they think that insurance companies will go and look at your full medical records, when, as we know, they often don't. So I think it's a good idea to warn the clients that, particularly when you're talking about their duty of disclosure and the risk of non-disclosure, that, you know, if you can't remember all of your doctor's visits, and let's face it, probably a lot of us wouldn't remember how many times we've seen the doctor in the last 5 years and for what, then perhaps I should be suggesting that the insurance company do seek a copy of their medical records and instruct the insurance company to do so. So in this particular case, as I've said, we felt that the advisor should have done that. We also found that he perhaps could have been a little bit more probing with Keith in asking some questions about his health, particularly because he knew that Keith had been a builder for 40 years, and we were dealing with people in their early 60s, late 50s, and although they disclosed a few medical issues, probably not a lot for people of that age group. But on the whole, we found that Keith and Nicole were primarily responsible themselves because of their non-disclosure and because of the fact that they'd cancelled Nicole's cover. They were primarily responsible for the fix that they now found themselves in. So in the end, we recommended that the advisor should pay $1,000 basically for a bit of stress and inconvenience, but that was the extent of the liability. Keith and Nicole, I can tell you, were not particularly happy with our decision, but after a bit more talking to them, they did accept the decision, and the complaint was resolved and a confidential settlement entered into. I won't talk about the third case study just at the moment. I'll just see how we go for time at the end. But I would just like to tell you here that we do have case studies on our website, www.fscl.org.nz. Those case notes are easily accessible. They are open for everybody to see, not just our participants, but they're there for consumers and other people as well. So I do encourage you, if you haven't already done so, if you've got a few moments in the day to spare, to go onto our website and have a look around the case notes, because they're quite interesting, and even if there are not a lot in your particular area of business, it's worthwhile reading some of the case notes just to see the types of issues we get and how we deal with them.
When I put the webinar recording up onto our website, I'll make sure I put a link to that that page on your website, Susan.
Great. Yeah, lovely. Thank you, David. So I'm just going to talk a little bit here about compensation. The cases that come before us involving sale of replacement insurance can sometimes be very difficult to determine what appropriate compensation is. And that's because it's often difficult to quantify what the exact financial loss is, and bearing in mind that we can award compensation up to $200,000. Now, in some cases where perhaps there's been a medical claim's been declined and the client has the estimated cost of the operation, it's relatively easy to quantify the alleged loss, which is, of course, the cost of the operation. But the harder cases are those where the insurer has found something out about the client and has told the client that they're going to be cancelling their income protection insurance altogether, or perhaps they're applying exclusions on their income protection or life cover for certain conditions. But the client hasn't yet suffered an event that would give rise to a claim, and of course may never suffer an event that gives rise to a claim. So, for example, perhaps an insurer has found out that because of a heart issue that the client may have had in the past, they're going to exclude any cover related to a heart attack or a heart condition. So when that sort of case comes to us, we're really being asked to consider the hypothetical, which is what is the risk of the client suffering an event at some stage in the future for which they no longer have cover. Now, one way of dealing with this is that we can make our findings as to liability. That is, we can look at what went wrong or what allegedly went wrong at the time the advice was given, and is the advisor liable or partly liable for the situation in which the client now finds themselves. And we might perhaps, for example, say, yes, we find that the advisor has contributed to the problem. Sometimes that might be a 50% contribution or more or less than that. And then we can defer the determination of quantum until such time as if and when an event occurs, because of course in the case I've just described, with a bit of luck the person will go on to live a long life and won't actually have any problem at all with their heart. In fact, some people that have had a heart issue and have been on constant medical watch and medication, perhaps less likely to have a heart attack than someone who's never had a problem in the past. But deferring the determination of quantum really isn't particularly satisfactory, as it doesn't provide any certainty for the client or the advisor. And for the client, of course, there's always the risk that the advisor will no longer be around or in business when they suffer an event some years down the track for which they have cover. So it's this type of case that, as I've mentioned earlier, is very suitable for conciliation, where a case manager from FSCL will get the parties around the table and attempt to bring about a satisfactory resolution. And this may involve the advisor paying some money to the client, which will give the client a certain level of security that they have some money set aside in the event that they suffer a serious illness or medical condition, or worse still die, but at the same time is a lot less than what the client would be entitled to if and when that event actually occurred. So, that picture I've got on the screen there is very apt. It sometimes does our heads in, and those involved in the case sometimes is actually figuring out how are we going to settle this case and what is fair compensation. That, of course, is assuming that we find that there is some liability on the advisor, because if there's no liability, then, of course, the complaint's not upheld. So now, moving on to my tips for best practice guidelines to avoid complaints. The first thing to remember front and centre, of course, is the fact that the Financial Advisors Act requires advisors to exercise care, diligence and skill when providing clients with financial advice. And we recommend that a comprehensive statement of advice should be provided to the clients, identifying two steps. First of all, disclosure, and then implementation of the policy. And the issues to include in this written document, we say, first of all, a comparison of product and providers. And this should state the specific reasons for the proposed replacement insurance and why the client's current policy cannot or does not adequately fulfill their needs and objectives. And ideally, these objectives should have been recorded in a fact-find analysis. We recommend that you highlight the key differences between the two policies, that is, the client's existing policy and the recommended new policy, that are relevant to the client. So, in other words, the product features, provider features, definitions. Sometimes different policies can have different definitions of key words. Any recommenced stand-down periods, obviously exclusions, that's a big one, and the provider strength and rating. Disclosure of risks, and we might do another quick poll here, David. I would really be interested to know, and I would hope we probably get 100% yes to this, is do the listeners always explain the client's duty of disclosure, including in particular the consequences of non-disclosure?
Okay, so we've got another poll coming up. The question is, do you always explain the client's duty of disclosure, including in particular the consequences of non-disclosure? So always, most of the time, sometimes never. So that's 62% voted, 70. I really would like to get 100% one time. So getting to 90, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Okay, let's close the poll and let's share the results. So as you suggested, Susan, the vast majority say always, so that's 82% said always. 14% said most of the time. 2% said sometimes, and 2% said never. So that's an interesting one. So I'm not sure how many that means in terms of numbers. There's probably one of the audience says sometimes, one of the audience says never. So
right. Well, you know, probably in my view, of all these guidelines, this is the most important one, and certainly most important one when it comes to avoiding complaints down the track. It's really, really important to highlight the client, their duty of disclosure, particularly the relevance of any medical events they've had since their existing cover was taken out. So obviously something that they may not have cover for if they take out replacement insurance, and the consequences of non-disclosure. Even if the client understands that they have a duty to disclose their medical history, they don't always understand that if they fail to disclose something that's material to the insurer, and of course it's really important, it's the materiality to the insurer that's important, not whether the client thinks it's important or not, they've run a huge risk of their claim being declined. And when that happens, you, the advisor, run a risk that the client will turn to you and say, you didn't warn me properly about my duty of disclosure and the consequences of not disclosing. The statement of advice should also talk something about underwriting risks. What is underwriting? Again, most of lay people won't understand what underwriting is. And again, that's where the disclosure becomes so important, because of course that will determine how the policy is underwritten and what terms the insurer is willing to offer to the client. The impact that underwriting might have on the insurer's terms and conditions, such as policy exclusions, premium changes, and the advisor's undertaking that you'll let the client know of any material differences in terms of post-underwriting. Cost and commissions. Obviously, you should be explaining the difference between what the client is paying now in respect of premiums and what they will pay if they take your advice, i.e. will there be an increase or a decrease in premiums, and if there's an increase, is that because they're getting better cover, the same cover, etc. You should explain that the premium is based on standard condition and may change after underwriting has been completed. Obviously, if there are some medical conditions there, it's possible that there will be a loading on the premium. And we recommend transparent advisor business remuneration disclosure, which looks like it's going to be required anyway in terms of the changes that are coming to the Financial Advisors Act. For example, the annual premium or commission amount, including soft commissions. You should explain the process as to how implementation of the replacement business will take place. And once the new insurer has accepted the proposal, obviously notify the client of any significant changes in terms compared with what you might initially have told them, receive the client's agreement to proceed with implementation if still appropriate, and the client's satisfied that it's still in their best interests, and remind the client that they have a 14-day free look period after receiving their new policy. In addition to this information, we also think it's best practice to document file notes of client discussions and agreements. We stress to all of our scheme participants that it's very, very important to keep good notes of meetings and important telephone conversations you've had with clients. A lot of the cases that come to us are he said, she said cases, and we often look to the advisor as the professional to have good file notes of their meetings and discussions with clients. And if you've got that, that can be gold dust for us when we're investigating a complaint. And of course, we recommend that you diarise review dates, such as when it's the next portfolio review should take place with your client, when premium loadings and exclusions are to be reviewed, if that's relevant, and policy expiry dates. And I think if you follow our best practice guidelines and stick to those, we hope that you'll never find yourselves in the position of having to front up to FSCL or your dispute resolution scheme with a client that's made a complaint about your service. And potentially, these complaints can carry quite a high level of risk if we're talking about a very expensive operation required, or a lengthy time off work for a client, or worst case scenario where a client has died. So, David, I think our 45 minutes is up, but I'm keen to take some questions if people have some questions for us.
Susan, that's been absolutely brilliant. I mean, and it's generated a whole raft of questions as we've gone through it, which I haven't brought up because I'm very conscious of time. So if you do need to go, guys, I realise that we publicised this as being a 45-minute session, but I think that the nature of the topic means that I would like, if I can, to at least move on, keep going for another 10 minutes or so. But if you do need to go, feel free to do so. I will put a recording of the whole thing up on our website early next week, so I'll make sure that you're aware of that. But there are, as I say, there are a number of questions. If I can just take 10 minutes to go through some of these questions, and some of them might actually come up as I've been thinking about what you've been saying, Susan. It's been a fantastic presentation. Thank you. Really
well, thank you. I haven't rushed through it. We probably could talk about this for all day, but I think
absolutely, I think we could, and I think it's possibly a topic that we may need to revisit because it's a really, really important topic. Okay, so let's talk about a couple of things. One of the advisors said that one of the problems of churn is that you have to buy a policy off the old broker. So churn is all about remuneration, or is typically one of the factors that's driving churn is remuneration. Mm-hmm. And if a new broker or a new advisor is talking to a client who has an old advisor on insurance of some sort, there is no remunerative incentive for that advisor to give advice to the client unless there is a product sale associated with it. So it starts to become a little bit challenging.
Yes.
And because typically the old broker won't transfer the remuneration entitlements in relation to the existing policy to the new broker, despite the fact that potentially the client may want to change brokers. I'm not sure there's anything that necessarily we can do about this. The nature of the agreements that sit in place between the insurance companies and the advisor.
Yes, I mean that's something, a policy matter really, that probably needs to be addressed, doesn't it?
Yeah. That,
there's a strong argument, I guess, that where a client wants to use a new advisor or broker, then the benefits remaining under that old policy should be transferred to the new advisor. Because if they're going to be the one meeting with the client and doing, regular follow-ups, they ought to be paid for that service.
Yes, and I think that is accurate, but I think traditionally the way it works is that remuneration stays with the original broker because it
Yes.
hasn't been traditionally perceived as being a servicing remuneration.
Certainly in the advisor industry, I have a feeling with insurance broking in the fire and general industry, and I stand to be corrected on this, I had a feeling that the service income is transferred if a person switches brokers. But could be wrong on that, but that might be something worth looking at.
Yes, yeah, absolutely. I think, as I say, an area that possibly needs further discussion. The other area that's there's two or three questions relating to the fact or the need for client disclosure.
Yes.
And even in my own situation, a couple of years ago, I took out a new DI policy with one of our advisors, and when it comes to completing a medical declaration, it is really hard to remember all the times you went to a doctor and what you went to a doctor for. I
Yes.
don't go to the doctor very regularly, but it seems to be a common theme that clients just don't remember
Yeah,
going to the
and I
doctor.
must say, I think probably 99% of us, I mean, I'm the same. If you ask me now to list every time I've been to the doctor in the 5 years, and like you, I don't go to the doctor too often, I'd struggle to remember every doctor's visit and why I went.
Yeah, yeah,
In that situation, what the client could do, of course, is to say on the proposal form that they have disclosed everything that they basically can remember, can recall, but they can say that there may be other doctor's visits I have had in the past 5, 10 years, however long, and say to the insurance company, I authorise you to obtain a copy of my full medical notes from my doctor and of the doctor's details. That then puts the onus on the insurer to do that if they've got a concern. And I think if at claim time a claim was declined and the client had put the insurer on notice that they should check the client's medical records, the insurance company would probably be in some difficulty in declining a claim for non-disclosure. So that's
right.
something to think about. I know that doesn't commonly happen at the moment. It's certainly what I would do if I was applying for new insurance myself.
Yeah,
Um,
that's an interesting,
but
interesting approach.
but that's something to think about, and perhaps suggest to your clients that if they're concerned that they haven't remembered everything and haven't written everything down, put the insurer on notice that they should check their medical records.
Yeah, yeah, I think that's worth investigating further and actually talking to insurers about what their perspective on that is. Because I think one of the challenges for insurers,
Insurers won't like that because it puts the work on them, and of course they don't want to have to go and for every proposal they receive go and get a copy of the client's medical notes. But,
yeah, because there's
yeah,
a cost associated with that, and
absolutely.
it's not cheap. And I guess the other approach is to then suggest to the client that they get a copy of the medical records because I think they're entitled to, aren't they, under the
Yes, they are, and they could staple them to the proposal, I guess. Mm.
yeah.
Yep, they could
So
do.
that might that yeah, so a combination of those two might well be appropriate. Um, the other question that that I had as we were going through this was in the areas of conflicts of interest. We talk about conflicts of interest and in particular remuneration. Do client the question is, and it may have come through in some of the complaints that you received. Do clients actually understand the implications of these conflicts?
No, they don't. They don't.
No.
Um, they, I think they understand in general terms, obviously, that the advisor is receiving commission. Because obviously the advisor must be being paid somehow. And honestly, I don't think the average Kiwi have any problem at all with an advisor receiving commission because we've all got to be paid for our work.
Absolutely.
And I think if they're regarded as the insurer paying the advisor rather than the client having to pay out of their own pockets, fee, so to speak, people have no problem with the commission. But I don't think they understand, obviously, the levels of commission, and where we do see some complaints raised is when the client sees that the advisor perhaps had a trip to Las Vegas or a trip to Prague or whatever, and that wasn't disclosed to them, and they find out about it at a later date. That tends to get up people's noses.
Yes, and I get that.
But again, I think a change is coming there, because my takeout of the proposed changes under the review of the Financial Advisors Act is that there is going to have to be more transparent disclosure, which is the quid pro quo for not tinkering with commission levels.
Yes, yes, absolutely, and I think that the AFA disclosure regime has suggested that it's not necessarily a negative, doesn't have necessarily a negative effect on business for advisors.
Yeah, no, I don't think it will have a negative effect at all. I think what is more negative, if you like, is when the client feels that something wasn't disclosed and that perhaps the advisor was trying to hide something. Whereas if it's disclosed up front, I think you'll find that your average person couldn't care less. It's when they feel that something's been hidden from them that they get annoyed.
Yeah, it's interesting, your first case that you talked about today, that is the one where they had three companies, didn't they? Was it the second case?
Yes.
They had three different companies. A transfer to a new company with no change in terms, I mean, at least in terms of cover, or a transfer to a new company. Did the advisor specifically articulate the remuneration effects of those two options to the client, do you think?
I don't. Well, he certainly did tell them that he would be earning commission for recommending the new company that he did. I don't think it came out until the complaint stage that he wouldn't have earned any commission had they just switched from company A to B. And
Right.
that, of course, raised their suspicions. So, again, it would have been in his best interests if he'd been completely upfront. I mean, certainly, yes, he'd done the right thing in telling them that he was being paid commission by company C, but he hadn't told them, actually, I wouldn't earn any commission if you remain with company B.
And so that's that fact that would have potentially influenced the outcome of that complaint.
Yeah, and certainly, and it inflames the complaint situation as well, which we were already dealing with some quite angry, actually, complainants in this case. And when they found that out, that was just sort of another thing that they could poke their finger at the advisor about.
Yeah, yeah. So being open and entirely honest, and actually potentially even explaining what those conflicts of interest potentially mean.
Yes, I think so. And if you've explained it and follow that up, document it either in your statement of advice or at least keep a file note that you've had that discussion with the client, it will, as I said, be worth gold dust to you if there's a complaint further down the track. Yeah,
absolutely, absolutely. This goes about documentation as well, doesn't it? One final thing, and I'm conscious of time because it's now 11:30. Do you suggest that where we're talking about things like the need for the advisor to explain to the client about the importance of disclosure, that the client signs off that the advisor has specifically articulated that to them and they understand those needs? So, explicitly articulate that or sign to say that, or even initial that particular.
Yeah, that would be good. We would certainly look to have a look at a good comprehensive statement of advice explaining the duty of disclosure and explaining it in reasonably plain and simple English. But yes, if you really want to dot the I's and cross the T's, it would be a good idea to get the client to initial that they've had their duty of disclosure explained to them. And I can't emphasize enough, it's not just the duty of disclosure, it's the consequences of not disclosing. Because people just have no idea that if they forget to mention the fact that, oh, I've had a bit of a niggly back for the last 5 years, and then, a year later require back surgery, that means that failure to disclose they've had a sore back on and off means that their claim's declined. Yeah. They don't get it.
Yeah, I got it. Okay, as I say, it's now 11:30. Conscious of time, there's still some other questions here that we could go through, and I think I'm going to take this offline. I may even think about possibly running a second follow-up to this session because it's of such importance. Susan, thank you so much for your time. If people do have questions that they want to raised with Susan, feel free to throw them at me, and I'll get them back to you, and I'll potentially put them up on the post that we put on the webinar. Susan, awesome presentation, very, very valuable. Thank you.
Great. Well, thank you, and hopefully you've all yes had some use from it today. I hope.
Almost certainly they will.
Right.
Okay, everybody, have a very good weekend. Our next webinar, as I say, is on the 5th of August. We look forward to seeing you online then. Thanks very much.